My name is Aaron Gott, and this is Antitrust 101. Everything you need to know about when to hire an antitrust lawyer. Antitrust law blends complex, high-stakes litigation with economics. But you don't really need to be an expert in antitrust law to serve your clients. You just need to know enough about antitrust law to know when there's an issue. This course is an issue spotting course. It's going to cover the basics of antitrust law, from cartels to monopolies to mergers. By the end of this course, you'll be able to spot antitrust risks and antitrust violations by understanding the basic concepts underpinning the federal antitrust laws. You will also learn the various types of conduct that violate federal antitrust law and the consequences for the violation. You'll learn about how the federal antitrust laws are enforced by governments and private parties, and how state antitrust law also plays a role in competition policy. You will also learn some key exemptions and immunities from federal antitrust law. In this course, we're going to talk about a few different things. First, we're going to give a little bit of background and history on the antitrust laws. Then we're going to talk about three substantive areas, including conspiracies, monopolies, and mergers. We'll talk about some key economics concepts. We'll talk about antitrust litigation and remedies. And we'll also talk about major exemptions from the antitrust laws. But first, to tell you a little bit about me, again, my name is Aaron Gott, and I am a partner at Bona Law PC. We're a boutique antitrust litigation firm with offices in 5 cities across the United States. I've been at Bona Law and practicing antitrust law for over 8 years, and I'm hoping that I can give you just a little taste of what I've learned in those 8 years. I've been lead counsel in several major antitrust cases involving price fixing and group boycotts, monopolies. I've advised clients on how to avoid going to litigation over the antitrust laws. And I've defended clients who found themselves in the unenviable position of being sued for violations of the antitrust laws, typically in class action multi-district litigation. With that, let's get started. You might be surprised to know that the antitrust laws have been around for a long time, virtually unchanged. It started with the Sherman Act, which was passed in 1890. Senator John Sherman was the sponsor. He was a Republican from Ohio who had been serving in Congress since the Civil War. And at that time, it was becoming apparent that a few people controlled a lot of commerce. So the Sherman Act was passed, and since then it's been considered the Magna Carta of free enterprise. The Supreme Court has called it a comprehensive charter of economic liberty aimed at preserving free and unfettered competition as the rule of trade. The Sherman Act has enjoyed broad bipartisan support for over a century. And if you think about it, it's quite amazing. Consider that Congress's commerce power is probably the most important power it has existed largely unchanged for the last 130 years. The Sherman Act is really important. It provides for exclusive federal jurisdiction meaning the cases can only be brought in federal court. And it has two main provisions. The first is Section 1 of the Sherman Act, which is about conspiracies. It outlaws every contract, combination, or conspiracy in restraint of trade. What that means is that it requires concerted action among more than one independent economic actor.